Joining us is Aaron Wright, a law professor at Cardozo Law School. And we've got Marco Santori, who is Chief Legal Officer and President at Blockchain. And last but not least, Andy Bromberg, co-founder and president of CoinList. So guys, I'm going to start off by asking you all to kind of unpack the title of this panel. You know, what are we talking about when we're talking about security and utility tokens? SAFT, I'm going to start with you.
Sure, and thanks so much, Lydia. I mean, I think that the title really kind of is a capstone for what we saw last year, which was the massive explosion in the sale of tokens. You know, I think one of the main mechanisms by which tokens were sold was through various different pre-sale agreements, like the SAFT, like other agreements that investors went into. And I think we've seen over the past year kind of the fallout from that, which is, you know, the SAFT and other pre-sale agreements are now the subject to multiple litigations. I think there's about 20 filed cases involving the SAFT. There's about 5 cases at least that actually have the SAFT as an exhibit. And I think that we've also seen kind of the end point of this from regulators, where we have an environment where it's going to be pretty difficult still to sell tokens to investors. And I think that that means that we're going to see, and we have seen, certain regulatory moats that are being basically ensconced around things like Bitcoin and Ethereum, and that's going to give them quite a lead. So I think that there still is room for utility tokens. We've seen some statements from the SEC and other global regulators about pre-selling or selling some scarce license in an online service are good. But I do think, at least in the short term, that we're going to see a lot more activity around security tokens and other more traditional financial services products. And then the end point is it's going to be harder to launch protocol-level tokens, which is, I think, a bit unfortunate. And I think the sad thing here is that we've also seen a lot of accredited investors just get wiped out. And that's unfortunate. So I think the tokens are still here. They're here to go. They're here to stay. I think we're going to see a lot more innovation there. But I think it's going to be increasingly difficult to do so. And even though we have seen some regulatory guidance from the SEC, I think that there's a lot of pitfalls and challenges for projects kind of going forward.
Marco?
Yeah, I disagree with most of that. I think that what we've seen over the last year is the standardization of transactional agreements. We published the SAFT framework in November of last year, and since then there have been almost no pre-functional token sales in the United States. And the SAFT framework has become something of a market standard, and so we've seen a lot come from that. As far as what the future holds, look, you have to understand this in context. The use of SAFT and the use of the SAFT framework in particular was mostly a reaction to the rash of these pre-functional token sales that occurred by the billions and billions of dollars in 2016 and 2017 and caused real consumer and investor harm. And when the SAFT project was born, it was born as a reaction to this. About a month after the publication of the SAFT project white paper, we saw no more pre-functional token sales in the United States, and of course functionality was the touchstone of the SAFT analysis. Since then, we've seen some feedback from the courts, we've seen some feedback from the regulators, we've seen quite a bit from SEC sort of iterating on their approach to where they draw the line as to what is a security and what isn't a security. First and foremost among them, those elements has been functionality, which was where we started on this a long time ago. But it's important to understand that the SEC is not the courts. They don't decide what is a security and what is not a security. They are a very powerful regulator, and they have quite a bit of say in that. I think where we are going to see more from this is from the courts themselves. We have, as Aaron said, plenty of litigation going on, both from ICOs, pre-functional token sales, and functional token sales or sales of securities. I think we're going to see much more from the courts over the next year, and that's going to change the course of all this.
Yeah, I'd largely agree with all of that. I think one more piece to add on is a terminology piece, and I think this is something that's really poorly defined in the industry, how we talk about what these different words, what these different terms actually mean. And so when I think about the title of this panel, or what we're talking about here, I hear a lot of buzz about this idea of security tokens, but for me, and this is just how we see it, a security token is a token that is and will forever be a security. The most common category of these that I think we see talked about are asset-backed tokens, where you have some sort of real estate interest or equity interest that is represented by a token. And that token is a security. It will always be a security. It represents a security. And that's how we define a security token. I think separate from that, you've had...
Sorry, buddy.
No worries. You've had SAFTs and other similar types of agreements, which are themselves securities. But as Marco was saying, represent future ownership of or future distribution of or future right to a non-security asset or an asset that's intended to be a non-security. Those I do not think are security tokens. I think those are just securities that represent a non-security token. So when I think about what the future looks like, I think, as Aaron was saying, we'll certainly see security tokens start to emerge where these assets that represent securities will be tokenized, and we'll see those start to exist. But I think we will also continue to see these securities offerings that represent future ownership of a non-securities asset. I think all of that is within this world of crypto that we're seeing going forward.
Yeah, and I think that's a great point. The tricky part here is that what differentiates some of those pre-sale agreements, SAFT or otherwise, and the token, it's just going to be gray. So we're going to have to go through the courts, right? Like Marco was saying, it's a great point. But just so you know what that means like a 5+ year slog until we have clarity there, right? It's going to hit district courts. Judges are going to make the determination. That's even there. It's not going to be particularly binding. It's going to go up to circuit courts. Different circuit courts could come to different conclusions. And ultimately, this could be the type of issue that goes all the way up to the Supreme Court, which could be great, right? We get clarity, but that's a 5-year slog. And the regulators, I think at this point, they don't really need to do as much, right? They provided an exceptional amount of guidance, at least historically based on what they provided before. They provided a really nice framework that kind of articulated and confirmed basically that US securities laws are going to apply when it comes to the sale of tokens. And it's that gray area which created a lot of risk off the bat. And I think it's going to take years to really bring that to some sort of clear resolution. A lot like what we saw with copyright, right? We saw Napster come out, created some questions around secondary liability for copyright infringement, and ultimately 5 years later, 5+ years later, went all the way up to the Supreme Court. And then we saw wonderful platforms like YouTube that were trying to really balance these two things. But here, we haven't started that process yet. So it's going to create a lot of confusion for wonderful projects and incredible entrepreneurs that are doing that. And it just creates a lot of risk for those entrepreneurs to kind of play around with utility tokens, which is a bit of a concerning situation for us to be in. And at the same time, it's creating new risk for protocols, right? So if you want to launch a new protocol level blockchain, you're going to have a hard time doing that, right? If you want to sell these tokens to investors, it's unclear that you're going to get much more guidance from the SEC because they face these asymmetrical risks, right? They're worried about providing too much clarity because we know, and history provides, that when you provide very, very detailed clarity, some bad actors will take advantage of that. And that means that they're going to be left holding the bag as a regulator kind of going forward. So it's a tough spot to be in, but I do think we're going to see a lot of innovation, particularly from more traditional financial players in exploring how they can represent assets on a blockchain, and we can take advantage of a lot of that innovation that we're seeing and have seen over the past 5 years. That's tremendous, and I think that will get people comfortable more with some of these token-based models, and eventually, like in 5+ years, we'll get to some sort of realistic conclusion to these questions.
So in light of all of these regulatory and enforcement and market developments that you've all highlighted, how do you see kind of trends in the use of security tokens in the US differing from what's happening everywhere else?
Yeah, I mean, and this is kind of another unfortunate situation because of the pervasive sale of tokens to investors in the US and the kind of muddled questions that it created. We've seen a lot of gray in the US market when in other jurisdictions we've seen a bit more clarity. So jurisdictions like Singapore, Switzerland, and even in the UK, we're starting to see a framework that basically says, hey, listen, if you're not selling a token to investors, what you're really selling is a license to use an online service, that's not going to, our securities laws in that jurisdiction is not going to apply. Here, though, the question is much more muddled, which I think is concerning because it could place US entrepreneurs and the development of the technology at a bit of a disadvantage. And at the same time, the flip side of that is existing platforms that have kind of been already determined to be commodities, at least in some sort of way, will have a huge competitive advantage going forward. It's going to be really hard to launch protocol level tokens in the US, I think, at this point in time.
I think that's right. And when I was a partner at Cooley, I was in private practice when we came up with the SAFT framework. One of the significant limitations to the SAFT framework was that it really only yields advantages in the United States, and the United States is in the minority when it comes to securities laws. We have this catch-all system, this catch-all definition of a security called the investment contract. You've probably heard about it 100 times by now. So the Howey test for what is an investment contract. Other jurisdictions don't have that. I mean, coolly, we had a global practice. The blockchain is a global company. Less than 30% of our users are in the United States, and we have to think globally. What we've seen and what we've seen in our policy interactions is that regulators in other jurisdictions have gone into their process, applied their laws, come out of the process with much more favorable laws toward the industry, and I think most people think towards innovation in general. But why is that? It's because they don't have the Howey test. They don't have the investment contract analysis. So in the United States, what we're seeing is, I agree, a really troubling phenomenon of utility tokens that really should not be securities under a meaningful test, sort of out of fear of regulation by enforcement, out of fear of this gray area, classifying themselves proactively as a security when they aren't one, when classification as a security wouldn't really yield any investor protection consequences. And worse yet, they don't understand that from a commercial perspective, that what they've done is lost that super negotiability that utility tokens and cash and other pieces of property ought to have, and instead traded it for this incredibly heavyweight regime of retransferability under the securities laws. It's actually really hard to transfer a security, and the whole point of tokens is liquidity, making them easy to transfer, making them fluid. So what we've seen is other jurisdictions take advantage of that, other jurisdictions rush ahead, and here in the United States, our regulators, I think, are doing an unprecedented and incredible job at determining and trying to apply these laws, but they're stuck with the laws that they have, and they're different here.
Yeah, one of the interesting pieces I want to hone in on that Marco said is this idea that classification as a security, in a large part, is intended to protect investors. The reason that these securities laws exist is to protect investors and enable the fair and orderly movement of markets. And what's interesting here is that for a lot of these tokens, classifying them as securities, like Marco said, doesn't actually yield meaningful investor protection or investor disclosures, because these token networks are not like equity. And so the disclosures that you have to make under securities law don't actually tell you that much about how the token networks work, and don't actually do that good of a job informing investors about what's happening and how risky the investment is. And as a result, I think one of the points here that's the most important is that it's not even in the spirit of the law under US securities law that these tokens that shouldn't be securities are being classified as securities. It's under the letter of the law that people are saying, I think I have to classify this like a security, I have to treat it like that, I have to deal with all these disclosures. But under the spirit of the law protecting investors, the securities law framework in the United States does not do a good job for token networks. And in large part because most of it was written in the 1930s, a good 70 or 80 years before token networks ever existed. And so the laws just don't apply there. And where I think other countries have done a really good job is saying, well, okay, how can we make sure that investors are still protected, still knowledgeable about what it is that they're investing in with these assets, even if they don't actually fit the definition of a security, and been thoughtful about what that regulation looks like. Again, to Aaron's point earlier about some of these jurisdictions that have made specific rule sets for token networks. That, I think, is the right way to go. It's what encourages innovation there. I agree, the regulators have done an amazing job interpreting these decades-old securities laws in the US to apply to token networks, but at the same time, in most senses and in most spirits of it, they really just shouldn't.
Could I actually pose a question?
Yeah.
I know it's your job, but I have a genuine question that I don't yet have the answer to. So we say the regulators are doing a great job, and they're doing a great job with the laws that they have. I believe that to be true, and I've always found that to be true. But there is a marked difference between the character and the substance of the guidance that two different regulators that focus on this space have given, right? On the one hand, well, first of all, SEC is not the only regulator when it comes to tokens. We also have to think about not just the securities laws, but the money services laws, which are at the federal level in the United States administered by FinCEN. So we got guidance from SEC. We've actually gotten quite a bit of guidance from SEC. But in terms of giving factual, sort of practical scenarios and fact patterns, SEC, we've gotten one practical scenario, and I think most of the people in this room would say that's actually not a scenario that most people would apply. The SEC came through with guidance that said, so long as you do a token sale in this way, you should be fine. Securities laws shouldn't apply. And one of the caveats was that the tokens can't be transferable. Think about that. It doesn't really apply in today's token world. Tokens are meant to be transferable. Compare that to FinCEN's guidance that gave over a dozen very specific fact patterns of real businesses that exist today and operate in the United States that make sense and make money. Those are two very different approaches to administering your regulatory regimes. I wonder how we got to that.
Yeah, I mean, I think one reason why we got to that, and I think it's a great point to just highlight that the SEC is just one of many players, right? Even beyond FinCEN, there's state securities law regulators. There's the CFTC, which obviously would apply if you're dealing with the trading of certain commodity-based tokens, and then there's obviously just the overarching anti-fraud statutes that apply at both the federal level and the state level. So it's a really complex interlacing web of transactions. I do think, though, we've seen a little bit more guidance from the SEC than that may be presented, which is in the form of various different enforcement actions. And that tends to be historically how the SEC rules. Right? They look at fact patterns and then they'll enforce. That creates a series of case law, or effectively something that can be akin to case law, which lawyers and other folks can use related to that. And I think we're seeing there a bit of an alignment around the fact that if you're marketing and selling a token as an investment product, and those consumer protection concerns kick into effect, and securities laws are going to apply, it's really this gray area of if the underlying substance of the token is supposed to be used as a license or some sort of access to a network, then what does that mean? Does that mean that it's going to be viewed as a commodity going forward? Does it mean it's still going to be considered a security? That's an open question, something that courts have not ruled on yet, and really the SEC hasn't provided much guidance. I do think the other reason why we're not seeing as much guidance from the SEC is the fact that consumers and accredited investors and lots of other folks, they lost a lot of money. And there's different parts of the SEC. They have a mandate to kind of support capital formation, but they also have a mandate to protect consumers and investors, right? And here we have a lot of investor and or consumer loss. And I think folks that are very concerned about that, their voices are now, I imagine, a bit more amplified in the current environment. So that's the tricky balance, right? There was a very aggressive approach that was taken legally in order to support some of these token sales, and that has now stunted the ability to get more clarity in the US as opposed to other jurisdictions. And again, the end point is it's going to be tough for entrepreneurs, right? And it's unfortunate because this technology is fantastic. It can solve a lot of the capital formation issues that we have here, where you have various different entrepreneurs that really can only raise capital in Silicon Valley, in New York, or other major metropolitan areas. It's going to stunt the growth of blockchain technology more broadly because it's going to create confusion, and lots of jurisdictions look to the US as kind of a rational and reasonable place where laws and rules are related, particularly when it comes to technology. And I think that it's going to be a slog. And we're going to see, I think, other states actually take the mantle here, like, for example, Wyoming has done a great job in clarifying some of these questions related to token taxonomy questions. They provided clarity when it comes to questions related to custody. They provided clarity when it comes to setting up various different businesses within the state of Wyoming. And I think that could actually be where we see a lot more activity recently at the state level, kind of showing this beautiful system of federalism that we have in the states.
Yeah, and to Marco's question, I also don't know exactly how we've ended up in this FinCEN SEC difference of how they approach this. I think one of the possible reasons, one hypothesis, is that it's easier, I think, for FinCEN to categorize different types of businesses with respect to whether or not something's a money services business, right? You can say, and this is what they did, they came out in this really interesting and well-written, in my opinion, guidance saying, well, if you're holding a key to a multi-sig wallet, you're not a money services business. But if you're a fully custodial one, then perhaps you are. And they went through all these different cases of different categories of businesses and whether or not they would need to register as a money services business under FinCEN's watch. And I think it's harder for the SEC with this so detailed facts and circumstances analysis of each case to be able to provide as clear kind of a taxonomy of cases and be able to give the examples. I think they could be doing more on that front and giving more, but it's just, I think, easier for FinCEN to bucket these businesses than it is for the SEC to bucket the offerings in as clearly defined a way.
So first I want to say we're going to leave some time at the end for questions. If you have one, feel free to go up to either one of the mics and we'll ask you to introduce yourself before your question. But I've got another one. So you guys have all talked a lot about securities, money transmitter compliance. We have mentioned the CFTC, but do you think that there is enough attention being paid, especially with the rise of asset-backed tokens? Is there enough attention being paid to commodities compliance and sort of going through and thinking about, is this product veering on something like a future or a product that would trigger registration requirements or other kind of due diligence aspects under commodities laws. Do you want to take that?
I got to tell you, I worry that there's too much. I worry that there's too much. I think the CFTC has shown tremendous ingenuity, tremendous foresight. They have been thoughtful. They have been great. Lawyers like to rank their federal regulators, and CFTC is near the top. They've been great stewards of this industry. But the CFTC, the SEC, for most of these tokens, those are the wrong regulators. Everybody in this room right now is caught up in this temporal bubble. The greatest and the highest and best use of crypto right now for a lot of people, especially those in this room, is poker chips in a casino. They're just ticker symbols for a lot of people. When I left Cooley and I joined the company side, I joined a company that was focused on something else. A place that was not a casino, a place that was not focused on speculation, a place that was focused on functional use in commerce, blockchain. That's important because these things are valueless as poker chips. I know there is a digital gold thesis. I believe it. I think it has merit. But in the long run, these things must work. They must be goods in commerce. There are regulators for that, both on the state and federal level, and they are not investment regulators. They're consumer protection regulators. They're consumer regulators for consumer goods. The Brooklyn Project is fond of talking about this, and they're right. The idea is that these things one day will replace functional goods in commerce, and they're already starting to. You can go to blockchain.com now, open a wallet, and actually use these things, not just place orders on a market. I think there's too much attention being paid to the CFTC, too much attention being paid to the SEC. We have to pay attention to them because we are practical people and they are our regulators. But at the same time, the focus should be on the functional commercial use of these goods.
Yeah, I mean, I think to your question, the tricky part is a lot of these token-based use cases kind of fall in between the authority of the SEC and CFTC, and other jurisdictions actually have unified regulatory bodies that cover both sides of that equation. And that has enabled them, I think, to move a little bit more quickly. There's always, some political economy question of different regulatory bodies working with one another. Who's going to have authority? Kind of where's the dividing line? So that's another complexity, at least here in the U.S., when it comes to that. That being said, I don't know if it has been too much regulation. Again, consumers have been hurt, right? I know we're at a wonderful Bitcoin and blockchain conference, and it's easy to get kind of lost in the fact that there was that these assets are worth a tremendous amount of money, but they went down considerably, right? And lots of people bought at that peak, and lots of people lost funds because of that. And I think that that's really what's driving a lot of the inquiry now. And I think that that's something that folks are going to need to explore on the regulatory side to make sure that we get the rules right. But I'm pretty optimistic here. Putting aside this, potentially like 5-year slog to understand kind of this gray area, the U.S. has tended to get tech policy at a high level correct. We kind of nailed it, I think, for the most part when it comes to the internet. If you think about all the applications that you're probably using today, many of them are US-based companies, not all of them, not as many in other jurisdictions, and I think we're going to see a similar pattern emerge here when it comes to blockchain. But I do think that it's important to recognize, particularly if you're new to the space, these are not poker chips, right? Or just poker chips. Really what they are and what tokens can represent is any asset, and that's what makes it so complex. They can represent traditional securities like uncertificated stock. They can represent licenses. They can represent loan interests. They can represent a whole host of other assets. And that's incredibly exciting and incredibly important as we think about updating this financial system that we haven't really been innovating on for hundreds of years, right? We have a new opportunity to do that. And it's going to touch a lot of parts of the economy. It's going to touch complex portions of our regulatory system. But ultimately, the U.S. is very pragmatic, and I think we'll come to kind of the right balance and conclusion here. It's a difficult process to get to that point. So be patient, but be optimistic.
You got nothing to add there.
Nothing to add. Okay, I want to see if there are any audience questions. Anyone want to step up?
Free legal advice.
You got 3 minutes. Oh, go ahead. Can you just say your name and who you're with before? The microphone, yeah.
Hi, my name's Adrian, and I'm a smart contract developer from Australia. And I've just put on a project building movies and royalty revenue streams. And so my question's more about the fairness of the regulation. So we've just gone through like a month-long process and thousands of dollars to actually get the green light for me to press play on a smart contract to deploy it. And so I think the best use case of some of these tokens is more for the royalty revenue streams of these artists. And so I'm just imagining a world where a young, music producer or a movie maker or anyone who's making some sort of creative good could actually issue a token on their future revenue stream. And I'm wondering, does a fan really need to be a sophisticated investor to get a part of that? More so that the fairness, because I can go to Las Vegas and drop $50,000 in baccarat. On one hand you try to protect the investors, but more just the fairness in this new world that we're building.
So this is not legal. That was a joke. This is not legal advice.
No.
But look, what I think the question you're raising is are the accredited investor requirements really fair?
Sure.
And that is an important political question that, I think if we took a show of hands in this room, it'd be a little bit skewed as to the broader population. But if you believe in the value of accredited investor requirements, that is to say, limiting particular private investments to the wealthy, then the answer is yes. That's absolutely fair, because the wealthy are in a much better place to take on those risks than the poor. If you disagree with the accredited investor requirements, then you're probably saying things like, well, I can be poor and buy a lottery ticket. How am I really being protected? Or I can go to a casino. How am I really being protected? I think that's an important political question.
It's more about like, let's say Justin Bieber wanted to give a royalty token for his early fans, and you should be able to be rewarded for being an early fan and be able to participate in the future royalty streams of Justin Bieber and not have to be a sophisticated investor. And so you don't have to purchase these royalty tokens, you can be given them.
Yeah,
do you have to be a sophisticated investor to be given something?
I think, from a policy perspective, I think, to Marco's point, I think you're really drilling down on some of the current tensions when it comes to who should be permitted to participate in lots of these blockchain-based use cases. But I do think, ultimately level heads will prevail. If it's a royalty payment and if you're using something for contracting purposes, from my vantage point and my position, that should be treated just like today. If you are receiving a royalty payment in some capacity, what does the law do there? We don't need to modify and change the entire legal construct to kind of understand that question. We should look today and see what laws apply to royalty payments, to contracting when it comes to the smart contract component, and that should give us a fairly clear answer there. I think the problem is that we were mushing together a lot of these concepts before, and that created a lot of confusion and a lot of gray area, which was basically we're selling something like a limited run Nike shoe or a ticket to a Broadway show as overt investment products. And that raises really difficult questions under the law. So I would just kind of keep a level head when you're thinking about some of these questions. But a lot of these use cases are great and they need to be built so people can see the power of this technology. Real-time royalty payments is pretty incredible.
I'm afraid we're out of time. Thank you to our panelists.